Hi everyone. Today's lecture will be on conservatorships and guardianships. Some of the learning outcomes from watching this video is you will have a better understanding of the difference between a conservator and a guardian. We will review the conservatorship and guardianship statutes, as well as discuss the conservatorship and guardianship proceedings. Now, what is a conservator? A conservator is a person responsible for managing the property and business affairs of an individual. A conservator is appointed through a legal proceeding, and the protected person has to be rendered unable to manage his or her property and business affairs. Conversely, we will discuss what is a guardian. A guardian is a person appointed to protect the interests of the individual who may not be able to act for him or herself by reason of being either 1, a minor, or 2, an incapacitated person. A guardian is appointed through a guardianship proceeding. A guardian typically makes decisions that relate to a person's health and non-financial affairs. Hawaii Revised Statute Section 560:5-106 states that family court maintains exclusive jurisdiction over guardianships of minors, and the probate court has exclusive jurisdiction over conservatorship proceedings for both minors and adults. The probate court has concurrent jurisdiction over guardianships of adult persons but not minors, where there is also a conservatorship proceeding concerning the same adult. So to recap, a family court has exclusive jurisdiction over guardianship matters, whereas probate court has jurisdiction over guardianship matters where there is also a conservatorship proceeding pending. Now, when should a conservator or guardian be appointed? Now, the Hawaii Revised Statutes, Section 560:5-401, states that the court may appoint a conservator of an individual if the court determines that for reasons other than age, and here are the two elements, by clear and convincing evidence, the individual is unable to manage property and business affairs effectively because of an impairment in the ability to receive and evaluate information. And then B, by a preponderance of the evidence, the individual has property that will be wasted or dissipated unless management is provided or money is needed for the support, care, education, health, and welfare of the individual. And so this is what the Hawaii Revised Statutes prescribes in order to have a conservator appointed. Now, the petition should recite standards and explain why the circumstances warrant the appointment of both a conservator and guardian. And then the standards can be found in HRS section 560:5-304 and 560:5-403. Now let's talk about the appointment of a guardian. Pursuant to HRS section 560:5-311, the court may appoint a limited or unlimited guardian for a respondent only if it finds by clear and convincing evidence that A, the respondent is an incapacitated person as defined by HRS section 560:5-102, and B, the respondent's identified needs cannot be met by less restrictive means, including use of appropriate and reasonably available technological assistance. Now, let's talk about the physician's letter or report that should be attached to the documents seeking the appointment of a conservator guardian. And so in the appointment for a conservator or guardian document, you need to identify the grounds for the incapacity of the person. So the grounds for incapacity are usually established by a letter from a physician who has examined the respondent. The physician's letter should address both the standards for the guardian and conservator as set forth in the statute. And Hawaii Probate Rule 102 draws a distinction between what information should be presented in a physician's letter in support of a conservatorship as opposed to one in support of a guardianship. And the rule, again, the relevant rule to look at is Hawaii Probate Rules Rule 102. Now here is Rule 102. and the subheading is physician's letters. And so for conservatorships, it says the petitioner in a proceeding for conservatorship may submit a physician's letter or report which states 1. The respondent suffers from an impairment. 2. The medical cause, a diagnosis of said impairment. 3. The prognosis. 4. The impact of the impairment upon the respondent's ability to manage the respondent's property. And 5. How long the physician has been treating the respondent. There's also this catch-all provision 6 where the physician's letter or report can state any other matter that the physician deems relevant. Now, 102 Part B addresses guardianship. So if you're filing something in court where you're trying to get a guardian appointed, and the guardian is someone who takes care of someone's health-related issues, or I should say non-financial issues, the petitioner in a proceeding for guardianship may submit a physician's letter report which states that the respondent is unable to receive and evaluate information or make or communicate decisions. 2. A description of the nature, type, and extent of the respondent's impairment. 3. The prognosis for the impairment. And 4. Any other matter the physician deems relevant. Now, there are notice requirements in conservatorship and guardianship proceedings, and the notice requirement requires personal service on the petition and the notice of hearing on the respondent. So the respondent is the person who the petitioner is trying to deem incapacitated, and so they need to be personally served that there is a conservatorship proceeding that is being filed against them. So personal service must be effectuated by any person who is not a party and not less than 18 years of age, and all other individuals entitled to notice may be served in person, by mail, or by any other method allowed by the Hawaii Revised Statutes. And so notice of the hearing must include a statement that the respondent must be physically present at the hearing unless excused by the court. You also have to inform the respondent of the respondent's rights at the hearing, and the respondent has the right to present evidence, subpoena witnesses and documents, examine witnesses, and participate in the hearing. And so you can imagine this must be devastating for the respondent in certain cases, because the typical situation is where we have a child who thinks that their parent is incapacitated, and so the parent would be the respondent, the petitioner would be the child, and because the respondent's rights might be taken away at this hearing, they have to be served personally, and they must physically be present at the hearing unless, of course, they're excused by the court. And in the situations where the respondent cannot be physically present, then they can be excused. Okay, so now let's talk about what is a kokua kanawai. And so once the petition for conservatorship and guardianship are filed, the court may appoint a kokua kanawai to review the petition. And so kokua kanawai means helper of the court. And so the kokua kanawai is typically an attorney who practices in this area, and the court will appoint them and pay them to interview the respondent and make a determination as to whether or not the respondent is really incapacitated and whether or not they think that a conservator or guardianship is appropriate in this case. So it's kind of a neutral third party, and the kokua kanawai explains the proceeding and the respondent's rights in the proceeding, and they serve as an extension of the court. And so here is the rule in the Hawaii probate rules that governs kokua kanawai, the role and authority. And so Rule 113 explains the role and authority of the kokua kanawai, and it states that a kokua kanawai appointed in a protective proceeding shall serve as and shall be limited to serving as an extension of the court to conduct an independent review of the situation, to interview the respondent and the person seeking to be appointed conservator or guardian, and to report its findings and recommendations to the court. And so in interviewing the respondent, the statute, Hawaii Revised Statute Section 560:5-406 talks about what the kokua kanawai should discuss with the respondent. And so in the interview, the kokua kanawai should explain to the respondent the substance of the petition, the nature, purpose, and effect of the proceeding. If the appointment of a conservator is requested, inform the respondent of the general powers and duties of a conservator. Determine the respondent's views regarding the proposed conservator's powers and duties, and the scope inform the respondent of the respondent's rights, inform the respondent about the costs, and the kokua kanawai shall also interview the petitioner, proposed conservator, and make any other investigation the court directs. And so this nicely sets forth all of the requirements for kokua kanawai, and this is something that the kokua kanawai will put into their report, which is submitted to the court. This is after the application for the appointment of a conservatorship guardianship is filed. Okay, and sometimes a guardian ad litem may be appointed by the court upon the filing of the petition. And so the court may appoint a lawyer to represent the respondent in the proceeding if it's requested by the respondent or it's recommended by the kokua kanawai, or the court determines that the respondent needs representation. So the guardian ad litem is basically a court-appointed attorney to represent the respondent in the conservatorship guardianship proceeding. Now, finally, I mentioned this briefly a few minutes ago, and this is the request to excuse appearance of the respondent. So the respondent and proposed conservator and guardian are required to attend the hearing unless they're excused by the court for good cause. And so if there are valid grounds to request that the respondent be excused, such as the respondent is physically ill, due to health reasons, a written request may be submitted to the probate court for review and approval. And so if the respondent's physical or mental condition is such that making an appearance would be difficult or futile, or where the proposed conservator guardian is otherwise unavailable, a written request may be warranted and approved by the court. Now that's all I have on conservatorships and guardianships. If anyone has any questions, feel free to email me, but yeah, this is just a brief overview. If you want to take a look more specifically at the Hawaii Revised Statutes, you may do so. But otherwise, again, let me know if you have any questions. Thanks.